Welcome back. This is IP Wonder. Today we will talk about whether you can sell or transfer a copyrighted work that you purchased through a legal download. First, do you know what rights you have for the copyrighted work you own? If you bought a book or CD or you received it as a gift, you have the right to sell, rent, display, or dispose of that particular copy you own. This is all because of the first sale doctrine under the copyright law. An individual who purchases a copy of a copyrighted work from the copyright holder receives the right to sell, display, or otherwise dispose of that particular copy. That means you can give away your Blu-rays, rent out the comic books you own, resell the design postcards you have, or throw away your CD copies. One thing to note is that there are no geographic limitations on the first sale doctrine. That means you can buy a painting in France and resell it in the United States. There was a Supreme Court case where a Thai student who studied in Cornell University found out that the textbooks sold in the United States were very expensive, so his family bought the same textbooks in Thailand at a lower price. He then sold the copies on eBay and made $100,000 by doing so. That's a lot! The book publisher sued the student for copyright infringement. The Supreme Court found the student did not infringe the publisher's copyright because the first sale doctrine applies. There are exceptions to the first sale doctrine. You cannot rent out copies of computer programs or musical works you own. Also, according to the Visual Artists' Rights Act, you cannot destroy certain artwork without the creator's permission, if such destruction would damage his or her reputation. Those artworks must be created in a limited edition of 200 copies or fewer. Also, they need to carry the artist's signature and are consecutively numbered. These days, we purchase music or video games online and download a copy of it for use. Most of the time, we get these copies through a license. By paying the fee, we are simply licensed to use the copyrighted content for our own enjoyment. No ownership right is transferred through a license, so the first sale doctrine does not apply. You need to refer to a license agreement to check what right you have. Finally, I want to remind you that you cannot photocopy or scan the book you purchased or duplicate the copyright work you own. Otherwise, you are violating the copyright owner's reproduction right. There's a Second Circuit case about it. The plaintiff owns copyrights in sound recordings of musical performances. The defendant is a company providing an online marketplace for users to resell the digital music files they bought. The defendant has a program that can verify its user's music as a lawfully purchased copy. The defendant then transfers the verified file to its server so that its users can sell the file through its marketplace for other users to download or stream the file. The court ruled that this transfer process involved unauthorized reproduction of the music file, and such reproduction was not a fair use. The defendant was found infringing the plaintiff's copyright. To answer today's question about whether you can sell or transfer a copyrighted work that you purchased through a legal download, first, you need to see if you are a licensee or an owner of that copy. Even if you have the right to sell or transfer, you need to make sure that during the process, you do not make any copies out of it. See you next time!